Madam Speaker, let me first of all thank all the honourable members from both sides of the House who have taken the floor and have contributed to the debate on this very important bill. And I'm glad also to note that there has been a general consensus in the House regarding this bill, which makes my task quite easy, therefore, in summing up. As I explained, Madam Speaker, in my second reading speech yesterday, the main object of this bill is to make better and more comprehensive provisions for the declaration of assets by public officials. And through this bill, we are fulfilling the pledge that we have made to the nation in 2014 during the electoral campaign in our electoral manifesto, and also in the government program 2015-2019, because we promised that we are going to introduce a new asset declaration system for M&As and for high-ranking public officers. Madam Speaker, I must say that this bill is neither intended to make everybody a potential suspect, nor to label any categories of public official as being corrupt. The ultimate aim of this bill is to create a new framework for asset declaration to enhance transparency and public trust in our institutions. Madam Speaker, an asset declaration system is one of the tools, amongst others, to fight corruption. But the one we had so far, that is the existing Declaration of Assets Act 1991, had become almost totally ineffective, and therefore it required a radical overhaul. And this is precisely what this bill purports to do. We are reviewing and revamping all the core dimensions of our asset declaration system. We have extended the scope of the assets to be declared. We have widened the coverage, that is the categories of officials who will be required to declare and file a declaration. We are proposing a new and more effective mechanism for the disclosure of the declarations, and moreover, sanctions for breaches of the law have been toughened. Madam Speaker, members from the other side of the House have raised a number of questions and issues in regard to some aspects of the bill. For example, why we have not widened further the breadth of disclosure, why not enlarge the scope of assets to be declared, why should the ICAC be the depository, and more importantly, on the disclosure rules that we have proposed. I must say that most, if not all, of the issues that have been raised by members have already been addressed by members on this side of the House in, I must say, in a very explicit manner. But nevertheless, I would like on my part, Madam Speaker, to take a few points. Let me take the issue of public disclosure, which is in fact a fundamental aspect of any asset declaration system. I noted that several members from the other side of the House spoke about this issue, including Honorable Adrien Duval and Honorable Ganou. Honorable Ganou also questioned why certain assets of M&As will not be made public. I think let me repeat this argument, that granting public access to asset declaration information is again an important dimension of an asset declaration regime. Of course, one can always argue over alternative options and cite examples from other countries. But I think that the mechanism that we have proposed here takes into account the local context. It is well balanced, and it will help to achieve the objectives of the new law. And I say this without jeopardizing the safety and security of the declarants. We live in a small country here. I must say, everyone knows each other practically in this country. Therefore, this balance is more than necessary in a small country, in a small democratic country like Mauritius, in order to protect the privacy rights of the declarants. Madam Speaker, I must say that there has always been this concern about safety and security. The question was raised, as has been pointed out by the intervener before me, in 1985, when the Declaration of Assets Act was introduced for the first time in Mauritius. And I must say, it's quite unusual when I was reading answered. The then Speaker of the National Assembly had expressed his concern, saying that, and I quote, I will only quote part of it, there might be a problem whereby the enjoyment of the private rights of any honorable member from whichever side might be abused, unquote. Well, the then Prime Minister had also raised similar apprehensions, which I must say were quite genuine and understandable. And as I said, times have changed also, yes. And over the years, Madam Speaker, such concerns for safety, security and privacy, although times have changed, they have not subsided also. And they are still very much present in our society. That is why we have moved. We have progressed, but we have progressed in a balanced way. And I must say, in some quarters also, people are also very wary because of the kind of media coverage that we have today. Also have, when I say times have changed, there are so many things that have changed because information is relayed now instantaneously. And where public figures and politically exposed persons are subjected. So we have to be careful. And I believe that we have progressed, and I agree, I am happy to note that the Honorable Member, Honorable Utim, said that we have made good progress, if I understood him well, good progress. But then again, we will be living and we will be seeing how this law does, and in time to come, if there is any need, whenever we take stock of what has happened, if there's any need to improve on the law would not be remain eternally like that. And I'm sure then when we take stock, when we learn the lessons, and when we see the loopholes also, we will obviously come forward to make amendments. But, Madam Speaker, when we make such laws, as I say, we must take into account the particular context in which the law will be applied, including also the unintended consequences. The concern for risks to security and the right to privacy, they are very legitimate, and they have to be adequately addressed. Admittedly, a greater degree of accountability is expected from elected officials. However, there is no compelling reason for public officials. Why is it for public officials, including elected officials, should not benefit also from the same protective provisions from our Constitution? And that is why I disagree with Honorable Juval, and I think Honorable Ganu also made the point. Why is it that we have disclosure for everything, complete disclosure? Can you imagine with regard to bank accounts, how much money you have? Although you don't want to hide anything. That is why you have to declare, but not to disclose, to make it a matter of public debate, and for people to have maybe, very bad intentions, people of crooked mind, let me say, who might be tempted to do illegal acts also. It should also be brought out that neither the United Nations Convention Against Corruption nor the African Union Convention on Prevention of and Combating Corruption imposes any obligation on state parties to go for full public disclosure. Madam Speaker, as I have explained yesterday, countries have adopted different approaches to address this issue. For example, in France, the content of the declarations of assets and the declaration of interests of the members of the government and members of parliament are made public. Declarations of interests of the French members of the European Parliament and mayors of big cities and towns are available on the website of the depository. In addition, the declaration of assets of parliamentarians can be accessed in certain government buildings, but they are not also published on the internet. The declarations of other public officials are not made public. Moreover, the following information from the declarations is not made public. That is, the personal address of the person who is required to file the declaration, for obvious reasons, the names of the spouse, partner, by civil union or common law spouse, the names of the other members of the family. Madam Speaker, on the other hand, in Australia, the law requires members of parliament to disclose their financial interests, including other assets. In UK, the House of Commons has two distinct but interdependent mechanisms for the disclosure of the personal financial interests of its members. They are the registration of interests in a register, as has been explained by Honorable Gayan, and that is open for public inspection. The declaration of interest in the course of debate in the House also. There's the Code of Conduct for members of the House of Lords that sets out a similar twofold system in place for the registration of interests of the members of the upper house. There are no formal asset disclosure regulations for the head of state or civil servants. Madam Speaker, in regard to Clause 7 of the bill, Honorable Béranger was inquiring as to the manner in which ICAC will disclose the declarations to the public. Let me say that the declared information will be posted on the website of the ICAC, and that the public will therefore be able to have access to the information through the internet. This, I believe, is a better option than having the information to be gazetted, as I believe Honorable Ganu was suggesting. A publication on websites is also a practice in many other countries like France, UK, the United States, where the information, obviously on declaration of interest, is disclosed to the public through the internet. Madam Speaker, we also heard a lot of hue and cry over the fact that ICAC is being made the depository. I would like to point out that both the OECD and the World Bank have advised countries which are in the process of either designing a new asset declaration system or are replacing the existing ones to take into account available resources, amongst other things. An asset declaration system is first and foremost a tool to combat corruption Therefore, it is very logical and normal that ICAC would be the one to be the depository, because it is the main institution in the fight, which is specialized in the fight against corruption. And I say, I don't want I mean, this argument has been made lengthily by Honorable Etienne Sinatambu. I must say that ICAC operates in an independent manner and is fully equipped to discharge its mandate, you know. Because I've heard Honorable Utim saying, well, there have been complaints against one person supposedly to be a member of one party, close to another one, and there have been other complaints. In fact, I haven't read the newspaper. I was just having a glimpse today. I saw Minister Mento was looking at Le Mauricien, and the first page, I think if I'm not mistaken, I saw that somebody has been requested to come to give statement under warning. Somebody who is in fact a member of my party. Now, if you know we were dictating ICAC to do this and that, well, we would have dictated not to call a member of my party. So ICAC is doing its work. We don't interfere in the work of ICAC. There are inquiries. I've answered questions whereby the case that was referred by Honorable Utim has been referred to ICAC on the recommendation of the one who presided the fact-finding committee. And this is being inquired. Now, do you expect, when I'm speaker, let us be serious. And the Honorable Member is a barrister. He knows, he has experience in those matters where inquiries are conducted. When the matter is referred, the inquiry starts. It does take time. But of course, we will judge whether the amount of time that is being taken for inquiry to be completed is not so unreasonable. Yes. But otherwise, we can't just already prejudge that, this is not being done, this is being done. We have no control over ICAC. So, let me therefore say that, and also ICAC has, I am informed, in fact I queried because I wanted to know, I am informed that ICAC has the necessary resources also to carry out the monitoring role, because as Attorney General has rightly pointed out, the whole process of declaring about, let's say about the public disclosure, this is one thing, but even for public disclosure and for, let's say, the declaration of other assets, it won't just stay with ICAC like that. There is going to be a monitoring process. There is need, obviously, whenever there is any information or any suspicion that somebody, let's say a declarant, is enriching himself, and there is at least some information, some evidence. Obviously, it will be the role of ICAC to do the monitoring process and eventually, well, refer the matter to any competent authorities which will investigate further, and again, eventually refer the matter, when the inquiry is completed, to the DPP, another independent institution. Let me also repeat one argument which has been very ably put forward by Honorable Gayan and Honorable Sinatambu, I believe. That's Section 59 of the Prevention of Corruption Act, and that was mentioned by Honorable Attorney General. The Parliamentary Committee of ICAC has been vested with this monitoring role over the Commission. The Parliamentary Committee will, pursuant to Section 61 of the Prevention of Corruption Act, monitor and review the manner in which the Commission fulfills its functions under the Act, including the manner in which the Commission will monitor the assets and liabilities of persons under the Declaration of Assets Act 2018. It is clear. But again, I fully agree with Attorney General. Well, each one must assume its responsibility. Each one of us must play our role also. When we are able to form part of a committee, we must seize this opportunity and therefore make the institution and committees work. Let me take another point that was raised by Honorable Ganu regarding the scope of the assets which will have to be declared. I think he got it a bit wrong, I must say. I don't know, because we've been sitting every day, maybe every one of us is tired. But it is so obvious, Madam Speaker, when you look at the bill, the definition of asset. It already includes securities. But I don't know whether he is confused. Securities including stocks, bonds, and treasury bills, or other units held in Mauritius or abroad. It does not mean securities means that. Securities are defined under the Securities Act, including all these. And the definition also includes assets held by a person for and on behalf of the declarant in the declarant's capacity as ultimate beneficiary. That is the asset held by a prête-nom. He was saying that, well, somebody, you can use the name of somebody. We know that. This has been common in the past. And that is why that is also covered. Let me also clarify that clause 4 of the bill does impose an obligation on the declarant to declare both his assets and liabilities. And again, I fail to understand how an experienced member like Honorable Ganu, because he said that, why is it that he doesn't include his liabilities? And he said it should have been set out initially in the first section of that bill. But maybe he should have read the explanatory memorandum of the bill itself. 2, it says, accordingly, the bill, and I'm reading, I don't want to read everything, but after mentioning all the persons who shall be required to make a declaration of their assets and liabilities. And there are the sections which deals with that. Madam Speaker, in designing the new framework that we have proposed, we have taken into account, amongst other things, obviously the weaknesses and loopholes in our existing asset declaration system and the evolution of the anti-corruption framework, and especially the available resources. And we must always bear in mind that there are considerable costs that are involved in maintaining an asset declaration system. And designing an asset declaration system always entails some trade-offs. And the trade-offs means adopting an approach that limits the scope of coverage, targets high-risk position, and also not to overstretch the capacity of the depository. That is why we believe in some countries they weigh the cost and the benefits of the different options. And I must say also that there is no evidence of any correlation between breadth of coverage on the one hand and effectiveness on corruption prevention on the other. We agree that obligations of M&As and...
Yes, again, whose phone is that? Out of respect for the dignity of the House, I would ask all honorable members to switch off their mobile phones. I have asked so many times.
So I was saying, Madam Speaker, we agree, however, that the obligations on members of the National Assembly and the senior officials should be relatively heavy. So admittedly, the question as to who should be required to declare his assets is linked not to the ranks, but to decision-making authority and managerial powers of the officials and the related risks of abuse of office and conflict of interest. And let me reassure, I think Honorable Attorney General has already responded to what Honorable Jangir has said with regard to members of bid evaluation committees, right? Because, you know, they are the ones who are, in a way, let's say, directly exposed and could be, you know, very tempted in a way. But they are, these people are covered. But at any rate, as we have put in the law, people who we believe, let's say in time to come, we see that there are categories of people who are not covered, we can always, by way of regulations, we can make the law. So, as I say, we also believe that an asset declaration system should not lead to a heavy burden on a vast number of persons also who are not public officials, because otherwise it will clog. It has been amply argued that it will clog the system. Now, obviously it has taken us some time to finalize this bill. Let me say that we have been very thorough while examining all the core fundamental aspects of this bill before it is being presented to the National Assembly, and I'm confident that we have tried to plug any loopholes. Let me say again, it may not be a perfect bill, but in any case, there is no, when I read of what has happened in other jurisdictions also, in other countries, there is no single best practice that is designed that will achieve every asset declaration outcome. Successful systems depend on factors that vary in the scope and intensity across countries. This is therefore the reason why there is no one-size-fits-all models, which we can import, let's say, from the shelf. Each country has to grow its own system to fit its own context, taking into account the parameters I have mentioned earlier, and also drawing inspiration from experiences from other jurisdictions. And this is exactly what we have done, Madam Speaker. So, the new asset declaration framework we have proposed in this bill will surely become an important element in our anti-corruption efforts. It will certainly enhance the culture of integrity in the public service and will contribute to maintain the confidence of citizens in government institutions. It will also serve as a constant and effective reminder to public officials of the duty of accountability that comes with public office. The point was made, and it's good that I do respond to that, because it doesn't concern only this bill. Just like the electoral reform, the opposition had doubts whether we would come before this House with a bill. Unfortunately, we came with the bill. Unfortunately, it has not been voted. They had doubts about whether we would be coming with a declaration of assets bill. I don't know if they still have doubts whether we will be coming with the financing of political parties bill. But, Madam Speaker, let me say one thing. Because the Honorable Leader of the Honorable Béranger said, when he looked at my answers to previous PQ, it seems the way that I answered, he had doubts whether we would come to the Assembly with a declaration of assets bill. But let me clear one thing. For one, I have always said that we are working on that bill. But until and unless we don't get a consensus within government, I can't give undertakings in this house. For example, they were already asking me, well, whether there is going to be public disclosure. How can I? Although I'm Prime Minister, yes, although I have my own opinion, but it is Cabinet who decides. And until and unless Cabinet has not taken a decision with regard to policy, with regard to what the bill will include, how disclosure is going to be made, I could not have given any undertaking to this House. But when I say something, Madam Speaker, and people will see through time, when I say that we are working, we will be coming with a bill, but I don't know when, but we will be coming, and I can assure this House, after the Constitution Amendment Bill, after this Declaration of Assets Bill, we are working, we have already rendered public the principles with regard to the financing of political parties. I hope there are going to be proposals or counter proposals with regard to that. We have given a time period, I believe it's 14th of January. So by that time, we will be working, and I am pretty sure we will be coming with a bill before this House. So a few issues that have been raised by Honorable Utim, let me respond to them quickly. Why is it that we have not included children of age, except for when there has been a transfer or assets have been bought, immovable properties, for example, have been bought and given to children of age? Well, we have grandchildren. Yes, grandchildren also, but children of age, first of all, and their children. No, but children of age and their children. Let's put it that way. Because if somebody, a declarant, has a child of age and has grandchildren, and that child of age would be acquiring any assets, any properties, and would be giving to the minor, his or her minor children, why is it that those assets should be declared? That's his or her business. Unless it is an asset which has been given or transferred by the declarant. Now, the Honourable Member is speaking about this is therefore a way we can contourner la loi. C'est trop facile, contourner la loi. Let me tell him that it is not trop facile. It is. There can be people who have, of course, crooked minds and would want to contourner la loi, but there are laws, there are institutions, and if such a thing happens, obviously there must be at least some evidence. I can assure him that there will be inquiry, and if it is found out that this has happened, well, that person will be taken to task under the respective law. Now, with regard to conjugal spouse, well, okay, fair point, but I don't think we can right now include that in our law, because where do we stop? Somebody living with somebody else? How do you know? How do you know it is in fact like a spouse? You can. I mean, we have seen. I don't want to go back to what has happened in the past, and you know, well, we have had a case where you know, girlfriends have been given so much in favor of I don't know what, but I don't think. Let's see how it works, and let's see if there are people who are again contourner la loi and trying to do something which is not appropriate, but where there is any loophole. Well, we will see, and then we will correct. Now, you mentioned also about subsidiaries, like you mentioned in case of CEB, but they are covered because they are state-owned companies. And then, yes, you mentioned something which I thought was we need to clarify. You said that, well, why is it that we don't put a value on the asset that we are declaring. And then whenever there is any change in the value of that asset, well, you have to make a declaration. Madam Speaker, we have discussed a lot about this. We have fought a lot about this. And we would have put it probably in the law, but it is not practical. Can you imagine the declarant would have had to monitor his assets every now and then and see, well, what is the value today, how it has increased in days to come, how it has decreased also probably, because they don't always increase. Value of shares, can you imagine? It keeps on, going up and down, going up and down. So it is not practical. It is for practicality that we have not included it. And then, well, I think that was wherever value of shares. Yes. So I hope I have responded to all those queries that have been raised. But let me say I'm again happy that there is consensus. It's a big step forward, and therefore I'm done with the seminar. Thank you.
The question is that the Declaration of Assets Bill number 23 of 2018 be read a second time. Those in favor say aye, those against say no. The ayes have it.
Public Bill Committee stage. Clause 1, short title. Clause 2, interpretation. Clause 3, application of act. Clause 4, obligation to make declaration of assets and liabilities. Clause 5, form and content of declaration. Clause 6, fresh declaration. Clause 7, disclosure of declaration. Clause 8, power to issue directives. Clause 9, power to monitor assets and liabilities. Clause 10, penalty for late submission of declaration. Clause 11, offences. Clause 12, prosecution. Clause 13, regulations. Clause 14, repeal. Clause 15, consequential amendment. Clause 16, transitional provisions. Clause 17, commencement.
The question is that clauses 1 to 17 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favor say aye, those against say no. The ayes have it. The question is that I do report to the House that the Declaration of Assets Bill number 23 of 2018 has passed the committee stage without amendment. Those in favor say aye, those against say no. The ayes have it. Please be seated. Honorable members, I have to report to the House that the Declaration of Assets Bill number 23 of 2018 has passed the committee stage without amendment.
Public Bill, third reading.
Madam Speaker, I move that the Declaration of Assets Bill number 23 of 2018 be read a third time and passed.
The question is that the Declaration of Assets Bill number 23 of 2018 be read the third time and passed. Those in favor say aye, those against say no. The ayes have it. I suspend the sitting for half an hour.